So you'll have a good understanding, I hope, from the first video of what I would see as the kind of foundational concept or idea in this area of Irish constitutional jurisprudence, that is to say Article 40, Section 1 based jurisprudence. The thought is really that it is difficult for litigants, for an individual litigant, to win a challenge to legislation that is based exclusively on Article 40, Section 1, as it were a pure equality-based claim. Why is it difficult to win? Well, the simple answer, I suppose, is because of the separation of powers. To add a little nuance to that, I guess it's the thought that, well, judges appreciate and recognize that drawing lines between different categories of citizens is an inherent part of the process of legislating. That effectively, almost any time that Oireachtas legislates, it draws lines between categories of citizens in terms of conferring benefits on this category and not on that category of citizens and so on. And that if the courts can invalidate legislation on the basis of Article 40, Section 1 readily, well then the courts effectively are drawn into the process of legislating. And the Constitution, of course, establishes that it is the Oireachtas that legislates, not the courts. Now, there are two doctrines or concepts that I want to share with you in advance of getting into the Donnelly case that flow from that essential idea and that have emerged in the jurisprudence over the decades. And the first is the notion of rationality, or the rationality test. Now, the idea here really quite simply is that in order to win a case, a litigant has to cross the threshold of the rationality test. Essentially, a litigant has to show that a distinction drawn by the Oireachtas isn't just maybe unfair, but it's irrational. Now, different judges have articulated this idea or concept in different ways over the decades. I mean, every time there's an Article 40, Section 1 case, pretty much I would say it's articulated by the judge one way or another. But the most influential one, I would say, probably is Mr. Justice Seamus Henchy's articulation of the idea in a case called Dillane and the Attorney General from 1980. You'll see this routinely cited, including by Ms. Justice O'Malley in her Donnelly judgment. And I'll paraphrase, if I may, but essentially Henchy says in 1980, he says, look, when the state makes a discrimination in favour of, and by the state he means the Oireachtas, the legislature, when the legislature makes a discrimination in favour of or against a person or a category of persons, the courts will not condemn such discrimination as being in breach of Article 40, Section 1 if it is not an arbitrary discrimination or if it's not capricious. In other words, if it's not irrational. And he goes on to say then, he says, whether the court supports or approves of that distinction is irrelevant. What matters is whether it could reasonably have been arrived at as a matter of policy by the Oireachtas. And I think that phrase there is quite important. Whether the court supports or approves of that distinction is irrelevant. And what he means by that is like as a political matter, whether it approves of it, as a matter of kind of moral political justice. In other words, what he's saying really there is, that's Mr. Justice Seamus Henchy is saying, he's like, well, I'm just a judge, or he's kind of saying like, I have obviously political views like anybody else. And if I had been a member of the legislature, I might have argued for drawing the line in a different place so that it would include people like the litigants, But I'm not a member of the legislature. I wasn't elected by anybody. And respect, I suppose, not just for the separation of powers and for the Constitution, but respect for the democratic equality of citizens, in the sense that everybody gets a vote, requires that the courts respect the assessment made by the Oireachtas, or the decision made by the elected representatives of the people, essentially. But of course, what that means is that there's this really, really high unless the determination the Oireachtas has made, is just totally indefensible. It's just totally irrational. And of course, what that means in practice is that there's this really high threshold, right, for individual litigants to cross in order to win a pure equality-based claim. So that's why I think Henchy's use of the word irrelevant is kind of striking to me. Essentially, what he's kind of saying is, look, my political views are actually irrelevant. My views and moral political views as to where the line should be drawn isn't really what should be governing me here. And most of us, I mean, even people who are, as it were, experienced constitutional thinkers and scholars, when we come upon an equality claim, whether it's the Donnelly claim, we will look at it now in a while, or EW or whatever, O'Mara, you always think, well, it really feels like these litigants should win. It really feels like they've been treated harshly here or treated unfairly here. And of course, that's not the question. As a constitutionalist, as it were, or a judge, has to try as best they can to look at it from a different perspective, and not from the perspective of what would I do if I were in charge of the world. That is a classical kind of a populist approach. A populist like Donald Trump, for example, or other kinds of populists would say, well, look, we're in charge of the court now. We should have our way with constitutional adjudication, or the judges on the Supreme Court should do my bidding. And, none of us is entirely immune to that way of thinking about constitutional law and constitutional adjudication. And I think in Henchy's articulation of the idea there, you get that sense of, well, look, this kind of like institutional discipline, if you like. Now, one of the arguments in Donnelly, as we'll see, the arguments that the litigants, lawyers representing the Donnelly family, made was that the rationality test should not be applied, that a lower threshold should be applied by the judges in the context. The so-called proportionality test should apply rather than, let's say, Henchy's rationality test, which would have made it easier for litigants, for them, to win their case. Now, the second doctrine that I wanted to consider with you but briefly before getting into the Donnelly case, because of course it comes up or is important in the Donnelly case because of a particular argument that was made by the Donnelly's lawyers, and that is the doctrine of the presumption of constitutionality. That's a doctrine that is judge-made. It emerges in the jurisprudence. In fact, it emerges in a judgment that was handed down right back at the very start of the life of the Irish Constitution, in a judgment in 1939 in a case called Pigs Marketing Board in Donnelly, judgment of Mr. Justice Hanna, who sets it out. But essentially it means that when a litigant challenges the constitutionality of legislation, the court approaches the question, on the assumption that the legislation is consistent with the Constitution. In other words, it's up to the individual litigant to demonstrate a clear repugnancy or clear inconsistency before the judges will contemplate, as it were, using their guillotine power, using their power to invalidate legislation. Why? What's the rationale for the doctrine of the presumption of constitutionality? Well, essentially, I guess, it's based on respect for the role of the Oireachtas under the Constitution. As Hanna explains it in that judgment, he says, in Ireland we've got this written constitution which enacts that the Oireachtas is the only agency, the only body, as he puts it, the only institution to pass laws for the peace, order and good government of the state. And it's submitted that their power, the power of the Oireachtas to legislate, is to be limited to these purposes, and that any law that's passed, that's enacted by the Oireachtas, must conform to this test. So the test is, well, what's in the public interest, or what's in the interests of, quote, the peace, order and good government of the state. And essentially what Hanna says is, well, look, that's a kind of a political question. In other words, it's not a legal question. To answer it essentially requires political judgment, and judges are no better placed to answer that question than anybody else is, if you like. And so therefore, judges should defer to or respect the assessments made by the Oireachtas, who after all have not only the constitutional authority but also the democratic credentials, if you like, to make those assessments. That's not to say, of course, that the presumption is never rebutted. The presumption of constitutionality has been there ever since 1939. Legislation is invalidated by courts regularly all the time, but it's just that there's a presumption at the start that legislation is consistent with the Constitution, and it's up to individual litigants to bring to the table arguments as to why, and maybe even sometimes evidence as to why legislation in fact is actually repugnant to the Constitution. So they're the two kind of key doctrines that I think you need to have a sense of in order to explore properly the Donnelly case and to understand the arguments of the litigants in Donnelly. I've promised that I will talk about Donnelly in this video, and it's kind of gone too late, I think. I don't want the videos to be terribly long, so I will talk about Donnelly properly in a third video. Let me just give you an initial flavour of, or sense of, the Donnelly case. So Robert and Henry Donnelly. Robert was the dad, Henry was the child. Henry was born in 2015, I think, with Down syndrome, and had other very, very significant and very, very serious conditions and complications. And the advice was, on the part of the medical staff, that he was not in a fit state, wasn't too unwell, or had too many complications to be cared for at home. The family lived somewhere outside of Dublin. They were advised that Henry should stay in Dublin, in hospital. And he spent the best part of 2 years of his life in hospital. But also, and this was advised by the medical staff, that one of his parents would effectively stay in the hospital with them, and actually would sleep in a housing that was provided by a charitable foundation next to the hospital. But Robert, the dad, would spend, I think, 5 days a week, would spend 12 hours a day or maybe 15 hours a day in the hospital room with Henry, and had to give up his job in order to do that. Meanwhile, the mother, Henry's mother, cared for their other children at home, and I think at the weekends perhaps she might swap and Robert would go home or whatever. So essentially, I mean, the family was in a very, 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 very chronic and serious situation, financially, obviously in other ways too, but also financially, in the sense that the dad had to give up his job to provide this care to Henry. And thankfully, eventually, Henry was well enough to return home, and the family did return home, and Henry was thereafter cared for at home by his family. But for that period of 2 years, Henry did not qualify for an allowance that was provided by the state called the domiciliary care allowance. The domiciliary care allowance was provided to families where there was a child with serious disabilities, where there was a need for care above and beyond the care that would be provided in, let's say, regular situations to children. But critically, under the legislation, it was made available to families where the child with the disability was being cared for by the family in their home. It was not available in the case of children with serious disabilities where the child was being cared for in institutions, including in hospitals. So Henry, or the Donnelly family, were ineligible for this domiciliary care allowance.